Here's a comprehensive analysis and guide to courtroom vocabulary for beginners, including key terms and their explanations. This will help individuals understand the basic legal language and processes used in courts. The official who presides over the courtroom, ensuring legal rules are followed and making rulings or judgments, is called a judge. The person or party who brings a lawsuit in a civil case is known as the plaintiff. The person or party accused in a criminal case or sued in a civil case is referred to as the defendant. The lawyer representing the state or government in a criminal case is called the prosecutor. The lawyer representing the defendant, ensuring their rights are protected, is known as the defense attorney. A bailiff is a court officer responsible for maintaining order and security in the courtroom. The individual who records everything said during the proceedings for the official court record is the court reporter. A witness is a person who provides testimony based on their knowledge or experience related to the case. Common legal terms include affidavit, which is a written statement made under oath, used as evidence in court. An allegation is a claim made by one party, yet to be proven. An arraignment is a court hearing where the defendant is formally charged and enters a plea, guilty, not guilty, or no contest. The burden of proof is the obligation to prove allegations, typically on the prosecution in criminal cases or the plaintiff in civil cases. A continuance is a request to postpone a court hearing to a later date. Cross-examination refers to the questioning of a witness by the opposing side to challenge their testimony. A deposition is sworn, out-of-court testimony used to gather evidence before trial. The docket is the court's official schedule of cases to be heard. Hearsay is an out-of-court statement introduced as evidence, typically not allowed unless an exception applies. Litigation is the process of taking legal action or resolving disputes in court. Courtroom processes include a plea bargain, which is an agreement where the defendant pleads guilty to a lesser charge in exchange for a reduced sentence or dismissal of other charges. Voir dire is the jury selection process, where potential jurors are questioned to determine their suitability. An opening statement is the initial presentation by attorneys outlining their case to the jury. Direct examination is the initial questioning of a witness by the attorney who called them. A closing argument is the final summary and argument made by each side to persuade the jury. Legal outcomes include a verdict, which is the jury's decision on the case, determining guilt or liability. A sentence is the punishment imposed on a defendant found guilty in a criminal case. A judgment is the official decision or ruling in a civil case. An acquittal is a verdict that the defendant is not guilty. An appeal is a request for a higher court to review and change the outcome of a case. Legal doctrines and concepts include the presumption of innocence, which is the principle that a defendant is considered innocent until proven guilty. Beyond a reasonable doubt is the standard of proof required in criminal cases to secure a conviction. Preponderance of the evidence is the standard of proof in civil cases, meaning it's more likely than not that the claim is true. Double jeopardy is the constitutional protection against being tried twice for the same offense. The statute of limitations is the time limit within which legal action must be taken. Miscellaneous terms include exhibit, which is physical or documentary evidence presented during a trial. An objection is a formal protest by an attorney against something said or done during the trial. Overruled is a judge's decision to reject an objection. Sustained is a judge's decision to uphold an objection. A subpoena is a legal order requiring someone to appear in court or provide evidence. Learning courtroom vocabulary is important because it improves understanding, enhances communication, and reduces anxiety. To master courtroom vocabulary, study glossaries, observe proceedings, and practice usage. Would you like further elaboration on any of these terms or additional resources to study?